Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Pulat. I think it's the second time on, but I think it's the first time we've got a chance to record. So he was back in the dark beginning days where I didn't realize how many people I can get and how many people I can talk to. And really excited to talk to you as well, because I know you have your own podcast, the Yunusov question. And we've talked probably a few similar people, same people. And so it's always great to have someone on the other side of the Mike, and I think it's probably a little different here for you. So thanks, Pulat, for joining us. And perhaps where you can start, tell us a little bit about yourself, how you got into law and a little bit about your practice.
Thanks, JP. Thanks for inviting me. I'm a lawyer in my 11th year of practice. Lawyers really like talking about how many years they practice law, and I'm not an exception. I think the 10-year threshold is really important for every lawyer. If I'm not mistaken, you qualify to be a judge after practicing law for 10 years. So it's like a magic point. It's the magic threshold, and I crossed it, and I'm still there. I started in 2011. I graduated from Osgood Hall Law School in 2010. I articled, then I started my own practice. I was in civil litigation from day one, civil, commercial litigation. The difference between the two is vague. Commercial litigation is really about, I think I would say it's about money. It's about money, transactions, commercial deals going wrong and things like that, property. Civil litigation, I would say it's a more encompassing, broader term. It definitely includes personal injury, insurance litigation, all things non-criminal fall under civil. I generally try to say that I do commercial litigation. I narrow the scope down because that's really what I do. I help or serve mostly companies, corporations, people who have commercial disputes or disputes arising out of commercial relationships, deals, transactions, things like that. So this is me.
All right. So I guess congrats on crossing that 10-year threshold. Maybe if you want to in the future, there Justice Yunusov in the possibilities there. I mean, at least now it's a possibility once you hit 10 years. Now, I mean, I think it's interesting that you went from completing your articles and starting your practice right away. And maybe you could tell us a little bit about how that process came about and what it was like starting your own practice, a year out from finishing, well, I guess months out from finishing your articles, and how did that all come about?
Once you jump through all the hoops, such as the LSAT, admission to law school, studying in law school, finishing law school, graduating law school, finding articling, successfully finishing articling, writing the bar exam, passing the bar exam, getting called to the bar, receiving your license to practice law. Once you jump through all these hoops, it's extremely easy to start your own practice. At least in our day and age, even back then, 11 years ago, all you need is your professional liability insurance. It's required by law, and one client. Once you have one client, even if it's your, I don't know, former classmate or neighbor, and even if it's over $500 or something like that, even if it's a small claims dispute, you are now officially a lawyer. Now, that's probably how I started. My first client, I think it was a very small dispute over a construction job or renovation job or something like that. And it was in small claims court. And then I did quite a few small claims dispute in my first 3 years of practice. Small claims court is a great school for litigators because you do trials in small claims court. Unlike superior court, where in your first several years, it's unlikely that you will do any trials, or if you work for traditional firm, it's unlikely they will let you do any trials in the superior court. In your first several years of practice in the small claims court, you get to do trials. And they're not that different from trials in the superior court. So I did a few trials in small claims court, great school, great training. If you want to know how to do trials. And I took it from there. And eventually I reached the point where I stopped doing small claims court work. So I do exclusively superior court work now, and some court of appeal work every once in a while, very rarely. My home court is Superior Court of Justice of Ontario.
So going back to those days of the small claims court matters, and I guess did you, when you started, I mean, you mentioned maybe it was like a neighbor, it was a very small construction thing, but did you have like a book of business, or did you have anything that you were bringing with you as you started on your own? And then what was that kind of feeling of, hey, I've set up, I've done all the minimal technical requirements, right? I mean, get the insurance and get the first client, and so to speak. But what was it like in terms of making that decision? Did you ever feel like I should continue on and work in a mid or large size firm instead, or why start your own practice?
If my memory serves me right, I intended to look for a job at the same time as I was doing one or two files here and there on my own, but I never really seriously looked for a job. So once I started working on my own files, getting my own clients, it really sucked me in. So I don't remember sending any job applications or anything like that. I might have made a list of company or law firms I wanted to apply to, but I don't think I ever did. So I quickly got rid of the idea that I wanted to work at a law firm or apply to a law firm very quickly, probably within the first 6 months. And I just focused on my own law practice. So I had to learn marketing. I had to learn about advertising. I got clients from all kinds of sources in the beginning. And of course, the curve was not very steep. And I'm talking about the revenue curve. The learning curve was steep. The revenue curve was quite flat for the first year or two until I learned a few things about the business side, until I learned a few things about marketing, until I learned a few things about law practice. And then it started sort of curving much higher, and I was happy. Basically, it took me a few years. It took me a few years to be satisfied with how much money I was making.
Now, for those who do go out or will go out and start their own practice and are looking to avoid maybe that slower sort of curve, or maybe it's not something that's really that avoidable, what can you say if you go back and look at when you made that jump from year 2 to year 3? What did you start doing differently than when you first started?
You charge more. I think it's the hardest thing to do for some people is to charge more. And I think some people get stuck on the rates that they charge, and they can't move them. And it's really unfair to them, to the lawyers. It's unfair to themselves not to raise their prices. So my advice to lawyers who feel confident, who cross that mark, 2-3 years of practice, is raise your prices. Look at what you're charging. Look at what others are charging. Maybe increase your retainers. Also look at the quality of your clients. In the civil, let's say, in the commercial litigation work, it's really important what clients you have. You should be selective. You should be particular. When you do other type of work, when you work with vulnerable groups, for example, as a criminal lawyer, as a personal injury lawyer, then the client intake is very different. You really are trying to serve people who are very vulnerable, and you have to take into account a lot more. But when you work in commercial litigation, when you basically help people recover money or collect debts or defend people against allegations relating to money, property. So everyone on both sides usually comes from a situation where it was all about money. Of course, there are cases where someone was taken advantage of, when someone is a victim. But overall, commercial litigation is about a dispute between two sides where both sides knew what they were doing. and both sides were in it for the money, some kind of commercial transaction. So it's only fair that a lawyer charges appropriately to the contribution that this lawyer is making. So that's really my advice to lawyers who choose this field, whether they are lawyers or paralegals, people providing legal services, because paralegals can do commercial litigation as well, that you charge proportionately to the stakes of the matter. If this is a commercial matter, if the money is at stake, you should be rewarded, you should be compensated accordingly. Should not be making any gifts to commercial parties that are in it for the money.
And one of the things there, from talking to you before, or from listening to you from before, is that from day one, you went completely paperless. Now, could you maybe just tell us a little bit about how that came about, and what's, what being paperless is, and how that sort of, I know we've obviously come a long way in the last 10 years with allowing more things. I know you talked to the Attorney General recently as well. Certainly some changes that have been coming about that make things a little bit easier, but tell us about that decision and what that means to be paperless, and how that saves on a lot of things with your firm.
That was a financial decision. I had to go paperless because I couldn't afford to be paper full. If I were to choose to be paper full, paper based, then I would have to get a lease to store all this paper in office. And I would have to get a secretary to shuffle all this paper. And I would have to spend a lot more time that I could be billing, shuffling this paper myself, pushing this paper. And I couldn't afford any of that. So I made a financial decision to be paperless. The upfront investment in being paperless, even back then, was almost zero. Google Drive existed even back then. I think even Dropbox existed back then. Virtual calls, Zoom calls, I don't think that they were big back then, but that didn't really have much to do with paper. Personal contact was the norm, even in paperless practices, until the pandemic. So for me, it was a financial decision. I was just trying to save money, and I could do it competently because I was a computer programmer before law school.
And so what are the things, like in terms of making sure that you're compliant with the Law Society rules and such as well? Like how do you store all the data and client information and everything to be both secure and as well accessible?
There are not a lot of Law Society rules specifically about the technical requirements for storing client data. There are some general standards. You have to protect client confidentiality, you have to protect client property. Everybody should go and read their respective rules of professional conduct for lawyers or paralegals. They say everything about that. And then you have to make a decision how to implement these standards in your practice, how to keep your data secure, how to protect your client's information. And a big part of that is notice. You have to give your clients notice about your chosen methods of storing and transmitting their data. So, for example, you can do it through the retainer agreement. You can tell the client in the retainer agreement that you will use email, and that email is inherently not secure. It's important to understand what inherently not secure means. Inherently not secure doesn't mean that sending something by email means that it will be intercepted by hackers the next second. No, inherently not secure means that it's probably not encrypted. It's probably going to be traveling through third parties' servers, computers, and that may keep a copy of the email. because that's how the email system, the global email system works. It relies on all kinds of intermediary computers to forward your email to the destination. So the important consideration here is the balance between convenience and risk. So the vast majority of emails that lawyers send, average lawyers send, are not sensitive. Okay? So email is perfectly fine for these for these messages, because nothing will be lost if somebody reads these emails. Nobody's really interested in these emails. And even if the opposing side, that usually is the party that can benefit the most from reading your confidential client lawyer emails, even if they read them, they can't rely on them in court because they are protected by privilege. There's a distinction between confidentiality and privilege. Confidentiality means that the emails are secret. The client usually is the owner of this confidentiality. They are secret, and the client is entitled to expect you to protect that secrecy by making sure people cannot easily read the emails easily, right? But privilege is different. Privilege is, again, the client's freedom from being forced to produce these emails in court, and from having his lawyer or her lawyer being forced to produce these emails in court. So even if someone breaches the confidentiality, privilege is going to be impenetrable. It's unlikely that they will overcome privilege unless confidentiality was breached in such a way that privilege also was waived, right? I don't want to get into that. It's really a complex evidence topic. What I'm saying is everyone is using email for a reason. But if you ever come across a file where confidentiality, not just privilege, but actual confidentiality is important to the extent that you have to take special steps to protect it, then you might want to consider an encrypted method of communication. I cannot tell you what to do, except to say that when you have a special situation where protection of data is important more than in an average case, average lawyer's case, paralegal's case, then you have to consult an expert. You have to talk to an IT person to figure out how you can protect clients' information. Because the problem with law practice is there are two sides to law practice, and we remember one and we often forget about the other. So one side is legal advice. We give legal advice. This is the core service that we provide. But the other side of law practice is protecting clients' data, property, and rights, making sure you don't lose them by accident or in other ways, right? So when you're a criminal lawyer, for example, your client can bring you some evidence. There are special rules about that for criminal lawyers that I don't even know. So you have to look into that. Same applies to paralegals who practice criminal law. But your client can bring you some property, even if you are their property, even if you are a civil lawyer, civil litigator, they can bring you some property. For example, they can bring you the original of a document where authenticity is in dispute. Then what do? This is the only original. There is a live issue in this litigation that will be determined with the help of this original. So it is valuable now, all of a sudden. So if you have a paperless practice, how do you handle that? You can't. You have to touch the paper all of a sudden, right? So of course, at some point, even if you start paperless, you will acquire filing cabinets and you will acquire safes, you will acquire secure storage facilities, depending on where your practice goes. But, it's also possible to avoid files where you have to take possession of any physical property. You can avoid files like that. So when you choose your clients, you got to screen files for things that work for you. One of these things is money, fees, solvency. Can they pay you? Another thing is, for example, is this going to be a burden? Because I will have to come into possession of a bunch of things, physical things that I don't want to, because my practice is paperless. So you have to think about these things up front. It's too late sometimes to do that after you take the file.
Yeah, that's great. And I guess when we want to go back then to talking about the first couple of years where you started with a lot of small claim stuff, and how do you kind of develop the litigation, let's say, strategy in terms of preparation? And certainly we can then follow this up and look at a commercial litigation file a lot different in terms of, from beginning to end. So what was like a small claims type of matter that you would have, and how would you kind of prepare from that, from beginning to finish? And what was that experience like?
It was a learning experience. I learned on the job. They don't teach you that in law school. I learned a lot in my articling. It was very hands-on, but it's still not enough. So you have to learn on the job, and you have to make sure you keep the standard, the professional standard of a competent lawyer. You have to do things competently. So I quickly discovered manuals and texts that you can find in the great library. I quickly discovered precedent databases when I was still subscribed to Westlaw. I'm no longer subscribed to Westlaw or any commercial database. So you look at what other people did. You look at texts and manuals that you can find in the library. There was not a lot of stuff online back then, and I think there is a lot more stuff online now. And you also remember that precedents, and I'm talking about law firm precedents, I'm not talking about court decisions, law firm precedents that people rely on so much in our profession, they exist to make that particular law firm's life easier. They don't exist because they are the ultimate truth. They don't exist because they are approved by the court. No, they exist because they make that particular law firm's life easier. That particular law firm that generated these precedents did it to support its own workflow. You might have a different workflow. You might actually have a different litigation philosophy. And it's not wrong to have a litigation philosophy almost from day one. Just make sure it's narrow in the beginning. Don't make it too broad. I mean, you don't know much in the beginning, right? So start small. For example, my litigation philosophy is that I'm not talking about me. I'm just giving you an example. So let's say you started your own practice, your own litigation practice, and you're thinking about your litigation philosophy. So start small. Start with something like, okay, my litigation philosophy is that I will return all emails, reply to all emails within 24 hours, right? That's a litigation philosophy. There's nothing wrong with it. And the sooner you choose something like that with a narrow scope, the better, because that will give you reputation, that will give you a name, that will give you a brand eventually. And then another example of litigation philosophies, I will never use high words in my written submissions. And when I say high words or big words, I mean like heretofore or same, not in the simple sense, but in the legal sense, and all other legalese terms that sometimes you find still in legal writing. If you choose to never use them, that's your litigation philosophy. And there are other things you can do right from the get-go to have a distinct approach to litigation, even if you are green and just started out.
And then I guess maybe you can walk us through now a commercial file, right? That somebody comes in, as you mentioned, a lot of times it's just a dispute about different people involving money. What are the, obviously the initial steps of getting retained and getting make sure you get paid, but what kind of happens from that day until potentially if it were to go to trial? What are the different stages?
I always tell clients that uh, that litigation consists of three stages: pleadings, discovery, and trial. I always tell every client about that, but this is a bird's eye view. If I were to talk about stages of litigation from the point of view of a lawyer, I would talk about a stage before pleadings, where you do file review and investigation. Pleading is probably as important as the trial itself, knowing how few files end up in trial, because pleadings, writing pleadings well, sharpens your focus, trains your litigation gun at the right target, and defines the four corners of the case that will then govern everything that happens later. So pleadings are so important, but before pleadings, you have to investigate the facts and the law enough to be able to draft pleadings. So you do a lot of work to draft the statement of claim or statement of defense. And a lot of that work is similar to preparing for a trial, not the evidence part of trial, but the framework part of trial, what the issues are, what the elements are, and things like that. You need all of that for trial. That's really the first part of preparing for the trial, but you already do a lot of that work at the pleading stage. So the first thing you do with a litigation file is investigate the facts and the law. And every lawyer has their own approach to doing that. You interview witnesses, you review documents, you ask someone to review documents, because sometimes there are a lot of documents. You ask someone to prepare chronology of the matter. And then you also do some legal research, or you ask someone to do legal research. I prefer to ask someone to do legal research.
Okay, so then you get from there into the pleadings, and I know you were talking about avoiding legalese there. You were mentioning that in terms of developing a litigation strategy there, but anything else you can add in terms of drafting pleadings that you found work particular for you? I know again everyone's different, but any kind of general tips there about putting everything together that you found very useful in your practice?
Pleadings are super important. So if your question is about drafting pleadings, I strongly recommend, if you're just starting out as a paralegal or a lawyer, go and read some pleadings manuals, some pleadings texts in the Great Library. And if you have a subscription to a commercial database, you can also download some precedents from the commercial database. Pleadings that other people prepared before you, knowledgeable people, experienced lawyers, are great because they turn your mind also to issues you might have missed when you reviewed the facts. Pleadings are really a consummate, full and finite list of all the issues in the case. That's why there is an expression, the four corners of the pleadings. You can't really step outside of these corners. So you better list all the issues in the case, spot them, and list them in your pleadings. If you have a defense, you better raise it in your statement of defense. If you have a claim, you better raise it in your statement of claim. And if you're just starting out, you probably should read other people's pleadings before, from similar cases. Let's say it's a condominium claim or defense. Go find some condominium cases. If you're just starting out in condominium law, you might not even be aware of the Condominium Act, but that's really the main thing that you should be aware about. The problem with our legal system is that we graduate lawyers who are completely clueless about essential elements of cases, and they take those cases. It doesn't happen with every lawyer. It doesn't happen. I don't know if it happens a lot or a little. I don't have the statistics, but all I know is that it happens. And because it happens, it's bad enough. How do you avoid being one of these lawyers or paralegals? When you take a case, look at what other people did with similar cases in pleadings. And pleadings are really a roadmap. They will open your eyes to issues that you should consider in your case. And it will also open your eyes to discovery pathways that you might pursue, the different questions you might ask on discovery, and also help you prepare for trial. So look at what other people did in the same type of case before. I don't know. It's really, sometimes there are traps that are really shocking. And they usually people who dabble, they fall into these traps. And just to give you an example, let's say you're just starting out and you heard that personal injury is lucrative. Okay, maybe you're wrong, maybe you're right. I don't know, no comment. But let's say you took a personal injury file. Okay. And then it turns out that you managed to reach a settlement of this file very quickly. You feel so proud of yourself. You feel that you served your client well. Your client signs the release. The matter is closed, the case is closed. And then it turns out that by statute, by legislation, OHIP is, in Ontario, is must get notice of claims of actions that involve personal injury. Why? Because OHIP is an insurer that paid presumably for treatment of these injuries, and they are entitled to a subrogated claim, which means they are entitled to a share of compensation that the injured person receives. I'm not a personal injury expert, so I'm not teaching you about personal injury law here, or subrogated claims, or liability of your client to OHIP. I'm just alerting you to an example of an issue that you may find out about only too late. Why? When you sign your minutes of settlement and the release, the insurance company is off the hook, or the defendant is off the hook, generally. Then OHIP comes in and says, okay, we have to take a share of the settlement to cover expensive treatment that we provided, right? Something like that. Look into that. May not apply to all cases, may not apply to even most cases, but it happens. It's just an example. And no one is going to tell you about it unless you started in a personal injury firm, an established personal injury firm, and they trained you, because they will just have a workflow for things like that. They will not start, or they will not take long to give notice to OHIP. They will know to give notice to OHIP. They will take that into account. They will know the amount of OHIP claims, if any, and they will take it into account in any settlement discussions or in any settlements. And they will serve their clients. But then there is you, presumably an upstart who never got trained in a personal injury firm, and you have to learn it the hard way. I practically never did personal injury law. I just happen to know about this. It's a stark example, in my opinion. And you will find that a lot of these traps exist where vulnerable people are involved, because government tends to pass legislation to protect the vulnerable, or government will tend to have some kind of scheme such as OHIP, to protect the vulnerable. And whenever vulnerable people are involved, you have to be super alert for legislation that applies, or for any other reality that applies and that may affect your client's settlement or any judgment that you may obtain on their behalf. So when you do commercial litigation, the beautiful thing about commercial litigation, a lot of commercial litigation, is that there are no vulnerable parties. So there is not a lot of legislation that the government has passed to regulate the facts of your case. It's less likely that such legislation exists. I mean, of course, there are specialized areas of commercial litigation that are specifically governed by legislation. I'm not talking about them, but in my own practice, it's just good old common law. So, and common law is a beautiful invention. It's a beautiful body of rules that very often jive with your own judgment and common sense if you develop it. So it takes a few years to develop your judgment, common sense, and sync with common law. But when you do, it's not that hard to be able to tell what the common law probably thinks about these facts.
Now, in the last couple of years, obviously, there's been changes to things in that process. Now, you nicely broke it down there with the pleadings, discoveries, and the trial. How has that affected your practice there in terms of some of the changes? What have you gotten used to? I mean, as we're kind of at a point where some stuff in the court system, depending on what area you're practicing, they may transition back into being in person. Some people love being remote. Some people hated cross-examining people over Zoom. What can you share from your own experience and how it's worked, what you've liked, what you've not liked, and any advice you can share for people who may be coming through at a time where, 3 years ago, this was not possible?
There's so much that I like that I don't even want to talk about what I don't like, because I can't think of anything. The amount of things that I like is so humongous. And I want to start with electronic filing. That was a pipe dream for years for me personally. Just the year before, in 2019, they wouldn't accept motion records with copies of signatures when you filed them. And then the following year, in 2020, they rolled out full electronic filing in Ontario. I couldn't believe my eyes. So electronic filing is amazing. And another thing that you learn when you deal with electronic filing is that there is a difference between the court file and what the judge will have before them in the hearing. And the electronic world makes that distinction. So the court file is a record of positions that any party to this dispute has taken. That's what it is. It's a record for posterity. Of course, before the pandemic, they would pull the file and put it in front of the judge. So they would bring the actual filings. Everybody was required to file only one copy normally, right? They would bring the actual copies or the actual motion records, the actual trial records, and so on, and put them in front of judges, and the judges would have those bound books in front of them in the courtroom. But the electronic era distinguished between the court filing and the hearing materials. So we have a separate system for the hearing materials called case lines. It will probably be replaced. You should watch the interview that I recorded with Justice Myers of the Ontario Superior Court of Justice last December. We talked a lot about things like that. But the basic fact about case lines is that it's a hearing software. You file your stuff through the provincial online filing system. That's the record for posterity. It's going to sit there. Then if you want to refer the judge to any materials during the hearing, you upload those materials to Case Lines. And Case Lines is basically like screen share. You show the judge whatever page you want to show from your materials. You take them on their screen to that page. You scroll the document for them on their screen remotely. So it's really great. It's really great. And I don't have a lot of complaints about Case Lines. Again, I have my lawyer hat and then I have my technologist hat. If I put my lawyer hat, I'm completely satisfied with the state of affairs. And I just have to think for a second about 2019 and then shudder with horror and be so thankful that we have what we have now. But if I put my technologist hat on, I can find long lists of things that I don't like about Case Lines, about the e-filing and everything. But I'm thankful. I'm grateful. I don't put my technologist hat very often. I usually have my lawyer hat on when I think about electronic filing. And when I do, I'm thankful because I always remember what it was like. And I always remember what it is now. And I'm very, very thankful. And I just keep my fingers crossed. And I hope that we don't backtrack even 1 inch, and that we only move forward. So on electronic hearings and on virtual hearings, what I hear is that lawyers, the majority of lawyers, want to continue the majority of matters to be heard on Zoom. Maybe not all trials, but the majority of motions and the majority of scheduling hearings, what I hear is that lawyers want them on Zoom. Okay? And for me, the Zoom has worked very well. I know that some lawyers are not as comfortable with Zoom. Zoom levels the playing field in some ways. For example, people look the same on Zoom. Like, think about it. We all look the same. We're all just talking heads. In the courtroom, you can tell if someone is very tall. You can tell if someone is very short. You can tell if someone is very bulky. You can tell if someone is very thin. You can tell if someone has a very loud voice. You can tell if someone has blue eyes. You can tell if someone has, Hollywood looks, whatever. On Zoom, we all look the same. We all sound about the same. So judges really, I think, this is my guess. I never played a judge. I never worked as a judge. But my guess is the judges focus more on the content of the submissions rather than on the appearance of the advocate. So some lawyers will lose the ability to deploy certain techniques that are connected to their mannerisms or appearance or voice and things like that. That will be consumed, that will be eaten by Zoom, right? So in that respect, Zoom is great. But yeah, some lawyers have probably lost some edge because of Zoom. And there's a group that really insists on in-person hearings, and who knows why? Well, maybe that's why, I don't know. But there are good reasons to do in-person hearings also. But not for everything anymore, not again. And the judges have said repeatedly that it will never again be that you will have to fly in expert witnesses from California just to sit in the courtroom for 30 minutes or for 60 minutes. You will not have to get them a hotel. You will not have to pay them per diem. You will not have to buy them lunches. You will not have them spend a couple of days in the city just to sit in the courtroom for an hour. We will have hybrid trials where even if the trial is in person, it's perfectly fine if some witnesses show up by Zoom. What's wrong with that? Right? And we will also have case lines in the courtrooms, even in in-person hearings. That will require some technology, some courtroom modifications, but they are happening. They are in progress. So lawyers, let's say there will be a big screen in the courtroom, and lawyers will be able to point the judge or the witness to the materials from their laptop, and the judge or the witness will see the page on the big screen, instead of everybody having their own copy of printed volumes and then the lawyer telling the judge or the witness what tab they should go to and what page. Instead, everybody's going to see the same thing on the screen. And we will save the trees, and we will also avoid mistakes, and we will also reap all other benefits of consuming the digital rather than the physical. The digital is way cheaper, provides incomparable scope of things you can do with it compared to the physical. You can do searches, you can do digital analysis, you can do summation, summarization, you can easily send. None of that is afforded by physical documents. So I really wish a quick end to all printed physical volumes in our courtrooms. Cannot happen soon enough.
Now, you just touched on it there in reference to one of your talks there with Justice Myers, but you could tell us a little bit more about the Yunusov question, how that came about, how that's been going for you, and what you've learned from talking to all these exceptional lawyers and judges and everyone else you've had on.
I'm sorry, I was just distracted by a call here. Can you repeat your question?
I was just talking, you mentioned Justice Myers there, and I know you've interviewed Justice Myers and many other lawyers and those in the legal profession on the Yunusov question. So can you tell me maybe how that came about and what was that like and what you've learned from that?
Yeah, so the Yunusov question was my attempt to meet people and talk to people in the very lonely year one of the pandemic. So I just wanted to break through those barriers and meet people and talk to people. That's why I did it. And it evolved slowly, I think, into a popular show for lawyers where we bring information to the profession about really important leaders and lawyers and judges in this profession and their human side. That's where we are right now. I'm really enjoying this. My guests are having fun. I think our audiences are having fun. So I think we're doing something useful. I get really good feedback. I'm really happy with it, and I hope to continue doing it.
Perfect. So thanks again for taking the time now, switching sides there and being on the other side of the question and answer. It's always appreciated here to hear from you. Any final words of wisdom for anyone listening and my students in particular? And once again, thanks for joining us and keep everything up there with the Yunusov question, and all the best in your practice.
Thank you so much. My final words are: don't be afraid. There is a lot of pressure in this profession to be afraid and to be scared. Don't be. It's a lot more doable than it seems. And reach out to people. You gotta be a part of a tribe. You don't do it alone.
Perfect. All the best. Take care, everyone. Have a great weekend.
Thank you.